Hello, my name is Ian Rubenstrunk. I'm a management consultant with Alliance Management based out of Minneapolis, Minnesota, primarily doing receivership work, turnaround consulting, and we do some healthy M&A work as well. Today, I'm going to talk to you about closing out a receivership, which is a very important but sort of often overlooked part of the receivership process. You get to the end, everyone's happy, there's a result, we're done, but there's some key considerations that we should all be thinking about, and I'm going to address those today. I have about 4 kind of main points to touch on: planning ahead, termination versus discharge, final report and accounting, and then the discharge order. So I'll start with the first one, planning ahead. It is kind of what it suggests, always looking through your order or your receivership statute at the beginning of the case to understand what's expected of you at the end. Much like a recipe, you want to read it from start to finish before you start doing something. For example, Minnesota statute 576-38 sub 3 requires a final report to have a schedule of all receivership property at the beginning of the case and then added thereafter. But the statute does not require the receiver to file an inventory at the beginning of the case. So if you're unaware of that requirement, you get to the end of the case, you read the statute, says, okay, final report, what's got to go in there? Well, now you're kind of scrambling, having to recreate records, and it's just not a great position to be in. You want to be doing these things as you go throughout the case. And the same can be said for, the appointment order as well. Understanding the statute, understanding what's required of you at all stages of the case can help inform what you're going to put in the appointment order to the extent you get input, but what terms, powers, duties, things do you want to put in that order that are going to help you wind up the case? For example, we commonly put in a provision about permissibility to hold funds for a certain period of time to wind up the case. We don't always need it. Sometimes it's not necessary, but just having that just in case, so we don't get to the end of the case and have to fight about that. We've already got powers and the expectations set forth. The next topic I'm going to talk about is termination versus discharge. The distinction is very important. Termination terminates the receivership itself, which means it cuts off the accrual of receivership property. It also cuts off the accrual of liabilities to the receivership. And finally, it cuts off the receiver's authority for decision-making as to, an entity. The receiver at termination will still have possession and control of the receivership property, but the receivership property is now a finite being. AR created if there's a discharge order entered on, a termination order entered on June 1st, any AR generated prior to June 1st is still receivership property. The receiver can still collect it, notwithstanding the fact that the receivership's been terminated. And anything post June 1 is someone else's property. No discretion or authority for the receiver over those assets. The discharge is going to end the receiver's liability to the court and as a fiduciary to the receivership property. So those two things can happen simultaneously. It's frequently easier for that to happen in sort of a liquidation scenario. Let's say we've been appointed as receiver over company, we sell all the assets, we've distributed all the cash, and all we're sitting with the pile of money, and we've done everything. Termination and discharge can happen simultaneously. We say we're going to be done, here's where the money's going, and that's all we have to do. In an ongoing business situation, that's a little more difficult to do simultaneously. It certainly can be done. It just requires a lot more anticipation of the unknown. So, let's say hypothetically, your receiver's appointed over an operating entity during the course of litigation. The parties reach a settlement. And so the receiver is no longer needed. The litigation can go away, but there's going to be issues about who pays the utility bills, what about that AR generation? What are you going to do with that? And so having that bright line date of termination, giving some lag time to pay outstanding utilities that are technically receivership liabilities and not, company liabilities, that sort of thing, makes the administration a little easier, a little smoother, and allows you to deal with unanticipated problems a little easier, as opposed to trying to do a lot of guesswork in the drafting of the termination or the discharge order. the last kind of piece on that is again, have a plan, right? Who's going to seek termination and discharge? Is the receiver going to do it? Is the plaintiff, is the defendant borrower going to do it? Whoever does it, the receiver should have input on that order. Again, so to make the administration and the wind up easier, given that the receiver is sort of in the best position to have, an understanding of what's needed to be done, so you should always make sure you have input on that order, have some say in it, which we'll talk about again here in just a moment. The next piece to cover is sort of the final report and accounting. Again, this common theme, check the statute, look ahead. What is actually required? A lot of statutes only require an accounting, but an accounting is really only a fraction of what the receiver does throughout the course of receivership. And you're going to want approval of all of your conduct, not just your accounting conduct. And so you look at not only sort of what is the bare minimum, but what's also required. And just because only an accounting is required doesn't mean you can't have other content in there. And then to that point, we'd recommend that a receiver always address all of its activity in a receivership, right, from day one through the last day. That can be certainly cumbersome. Sometimes you can incorporate that by incorporate your conduct through prior reports. If you're filing monthly, you can say, we incorporate all the prior reports. That's an easier way to do it. If you're not doing it, or if you're doing quarterly, having a detailed report at the end of the case is not a bad idea, because everything you've done now has been blessed by the court. And then, be comprehensive, right? That, you won't leave out some issue that, or some act that took place that someone could argue about later. And that kind of leads into the next point about service. And again, this is sort of an overlooked thing. Typically, a receiver just says, okay, my counsel, here's my report, hand it off. Counsel, you go serve it. I think that I would recommend to make sure you're aware of who's getting served and advise your counsel on the parties that you want to be served with the order. Our recommendation would be you serve every party that you've ever interacted with throughout the entire course of the receivership. And that's really, again, geared towards having finality. Let's wind up the case and really be done. You don't want to run into a situation where there's a creditor you talk to from months 1 to 3. Now you're in month 7 of the receivership. That issue, as far as has been resolved. And then 9 months after you're discharged, they show up and say, hey, I didn't know this case was being wrapped up, and I have some bone to pick with the receiver about something that they did. Now you're in a situation where the case is closed. Who knows where the plaintiff is, where's the borrower, or where's the receivership? I mean, it just creates a lot of headache and complications. And so to that point, we recommend, creating a very comprehensive service list. Say, here's, we're winding up the case. Speak now or forever hold your peace. And then if they don't, and you gave them service and service was proper, then that argument in that situation, that 9 months post close of case situation, becomes a lot easier to deal with, because they weren't compliant with the process and the procedures set forth in the orders. The last piece I'll talk about here is the discharge order itself. Having those findings is really important to the receiver. It's probably less important to some of the other parties. But again, we want to get a blessing for everything that we've done, right? You want a finding from the court that says all of the conduct of the receiver has been in good faith. Everything they were supposed to do, they've done. But also clear expectations as to what's going to happen once the receivership is terminated and once the discharge occurs, right? Rarely is there going to be a situation where it's just handing over keys, right? There's going to be unadministered assets. There's going to be unadministered liabilities. There's going to be, if you did a claims process and you sent 100 checks out, 4 of them won't have been cashed in, the 3-month period that you allowed for. So what do you do at that point, right? And you want that order to address that situation. So again, you don't have to end up in a situation where 9 months after the case is closed, now you're coming back saying, what do we do, right? The parties in interest are probably long gone. And so we want to avoid kind of those situations. And so it's focused on bringing finality and anticipating issues. Having clear expectations of, in the operating entity example I talked about earlier, who's getting the property at the end of the case? Maybe that's going to be dictated by the settlement. Well, if that settlement is between the plaintiff and defendant, and the receiver's obligated to give it somewhere, let's make sure that term makes it into the order, right? So because the receiver only answers to the court. So who's going to assume liabilities, right? If liabilities aren't paid, if the electric bill, for April comes up and you're discharged in May, and April never got paid for some reason, who's going to handle that, right? The last thing you want to be as a receiver is in a position with a third party having a claim against you individually because you didn't do this, that, or the other thing. So having a clear expectation that you can point to in the order after the case has been closed, it says, this is no longer our problem. We all agreed that this party would be taking over this responsibility. And then the last part is, the unadministered assets. Again, having a clear plan for what do we do with everything that's left over. Obviously, cash is an easy thing to deal with. If if it's a liquidation situation, plaintiff's been paid in full, hopefully. What else do we do with this remaining cash? And then balancing that with, okay, could we do another distribution to creditors? Or let's say it's $500. Making a proposal. Typically, we'll propose donating it to charity, obviously with the court's approval. That's an easy solution. Dealing with tangible assets is a little more difficult. I'll say the borrower's a landlord and they're long gone, they're wind up, they're not going to exist anymore. Or sorry, not a landlord, a tenant. We might recommend, say, we're just going to abandon, right? Abandonment is always an option. You can leave the property there and then let the landlord exercise their remedies under state law to deal with the property that's left behind. So those are sort of just the kind of the key points to winding up a case. There's obviously a lot of different things we could talk about for a long time. But kind of the main takeaways are going to be planning ahead. Always, at the beginning of the case, know what's expected of you at the end. Finality, anticipating issues at the end of the case. And then, being clear with the expectations with the parties and the court as to when you're done and what's going to happen when you're done, so that we don't have to come back again and deal with issues that, no one thought of.